My name is Laura Clark and I will be reviewing the facts and findings of the High Court case of Avel Proprietary Limited and Multicoin Amusements Proprietary Limited and British Amusements Proprietary Limited. This matter relates to Section 202 of the Copyright Act 1968, being threats of legal proceedings in respect of an infringement of copyright. The parties to this matter are Avel Proprietary Limited, being the distributor, Multicoin, affiliated with British Amusements affiliated with Multicoin, and Williams, the exclusive manufacturer of various coin-operated amusement machines in question. To give some background facts, Williams is the exclusive manufacturer of various coin-operated amusement machines, called the Games. Williams and the distributor, Avel Proprietary Limited, agreed that the distributor will have sole and exclusive rights of distribution in Australia in respect of the Games upon the terms and subject to the conditions in the distribution agreement. On 1 May 1986, the distribution agreement was entered into between Williams and Avel. Out of the 28 operative clauses within the agreement, 2 clauses are of primary importance in this case. Number 1, rights of distributor, and number 2, sole rights of Williams. It is common ground that from time to time, Williams and Avel agreed to apply the terms of the agreement to other models of pinball machines, including Williams' Pinbot. In early February 1987, British Amusements imported into Australia from the United States 9 new and 5 used Williams Road King machines. Avel responded by publishing an advertisement in March 1987 claiming exclusive rights for a number of games, including Williams Pinball games, since 1985. Avel threatened to institute legal proceedings without notice against any person, firm or company who imports, manufactures, distributes or operates any game which is an infringement of Avel's rights. The director of British Amusements responded by claiming, on behalf of British Amusements, that the company's marketing of Road King machines did not infringe the rights of any other person. And so began exchanges of correspondence and threats between the parties via their solicitors. In an attempt to avoid any possible copyright infringements, as alleged by Avel, in November 1987, Multicoin ordered a consignment of used Williams machines from 2 American dealers, Worldwide Distributors Inc. and C.A. Robinson & Co. Inc. Avel became aware of the consignment and wrote to threaten Multicoin of legal action. On 22 June 1988, Multicoin and British Amusements instituted legal proceedings in the Supreme Court of Queensland. The relief claimed in that proceeding was a declaration that the threats made by the defendant, being Avel, are unjustifiable, pursuant to Section 202 of the Copyright Act, and claimed damages. The major issue at trial presented by the plaintiffs was the justifiability of the threats made by Avel, both in writing and via solicitors, in relation to Section 202 of the Copyright Act 1968. The defendant, Avel Proprietary Limited, cross-claimed on the following basis. Number 1, making a declaration that threats were justifiable, and number 2, requesting an injunction restraining the plaintiffs from infringing copyright of Williams games and acting in contravention of the defendant's rights under the distribution agreement. In relation to the consignment by Multicoin from the other American dealers, the court ruled that the threats made by Avel were not justifiable, as Avel's distribution agreement did not extend to the particular model being imported. His Honour ordered an injunction restraining any further threats by Avel. His Honour therefore awarded Multicoin and British Amusements damages. His Honour also ruled that the other threats made by Avel were justifiable, as Avel was protecting its rights as exclusive licensee of Williams. His Honour made an order restraining present appellants against infringing Avel's copyright. The matter was then cross-appealed by Multicoin and British Amusements to the Federal Court of Australia. Multicoin and British Amusements complained that 1. The trial judge ought to have held that none of the threats made by Avel were justifiable. 2. They argued that Avel is not an exclusive licensee of the relevant copyrights. And 3. They also claimed that the damages allowed by the trial judge were inadequate. Avel claims that it is the exclusive licensee with reference to the distributor agreement between itself and Williams. The Federal Court gave careful analysis of the distributor agreement and the rights set out in it. The Federal Court ruled that the position taken by Avel is misconceived. It is not an exclusive licensee. Avel has no standing to restrain any infringement by the appellants of Williams' rights. Avel has failed to demonstrate any infringement by the appellants of Williams' copyright. In the Federal Court's opinion, the trial judge ought to have held that the threats made by Avel were not justifiable. His Honour should have restrained Avel from all threats made against the appellants. The Federal Court also increased the amount of damages awarded to Multicoin by the trial judge. The matter was then appealed to the High Court of Australia by Avel Proprietary Limited with some concerning questions. Number 1, the construction and effect of the distribution agreement. Number 2, the construction and effect of the Act, the Copyright Act. Number 3, questions of admissibility of particular evidence and of the effect of the overall evidence insofar as entitlement to relief is concerned. Chief Justice Mason and Justices Dean and Gaudron held by majority decision the following 3 points. The construction of the distribution agreement between Avel and Williams does not refer to individual identified machines, but to particular models or types of machines. The distribution agreement did not make the distributor, Avel, exclusive licensee of the copyright in the artwork or the computer programs of the particular models made by Williams. And 3, the distributor, not being an exclusive licensee, could not itself bring proceedings for infringement of copyright. That being so, the Federal Court was correct in holding that the distributors, being Avel's counterclaim, failed. By majority decision, the appeal should be dismissed. This High Court case of 1990 goes to demonstrate the contentious issues surrounding intellectual property law in Australia and how it continues to be so in the present day, as the law struggles to mould to correspond to our changing domestic and